This is Jonathan.
Captain Hatch, please.
Sure. Hold on just a moment. Let me get Studio's extension. Bear with me just a second while I find that. One moment.
This is Hatch.
Captain Hatch, this is Charles Stark calling you back.
How are you, sir? What can I do for you?
I'm doing well. I'm trying to report this aggravated assault, and nobody seems to want to take it, which kind of bothers me. So I was in your jail, and I was pepper sprayed by Lieutenant Harris, okay? And so I know this. I haven't been found guilty of any crime, okay? And federal law reads that a pretrial detainee cannot be punished for any reason whatsoever, okay? So not only that, I already talked to somebody, Professional Standards, Mrs. Hawks, who's actually really nice. She shipped me over to criminal investigations, and I spoke with Sergeant Teague, I think was his name, who's been absolutely no help whatsoever. And so now I'm going to come to you about this aggravated assault charge. That's what it is. It's aggravated assault. I was not a threat. My hands were by my side. I was not. I because I didn't listen to them. So when I was there, I sent a couple of emails in that kiosk, and they said you were being non-compliant or passively non-compliant, whatever that means. That's not legally good.
What's the correct spelling on your last name?
Starke. First name Charles.
Is it?
Charles.
That's how it appears on your driver's license.
Correct.
Charles
B. Stark Jr. The license, the Texas DL is 11114291.
You were here when? November?
Yes.
Is that when this incident occurred?
It did. As a matter of fact, no, my hands were by my side. I wasn't a threat. I asked him a question: why they're removing the other inmate? I asked him that. He's like, "Get on your knees." I said, "For what?" He said, "Get on your knees." I said, "So what happens if I don't?" I was just asking what would be the consequences if I didn't do it, and he pepper sprayed me. And then 6 of your guys tackled me to the ground, threw me down 4 upstairs, handcuffed me, drug me to the nurse's station, where they had to spray my eyes like 10 or 15 times, and then they put me in some room with no towel, no nothing, because I couldn't see. I was blind. They left me there for like an hour, just sitting there. Okay. Now, legally, sir, I know that's torture per Title 18 U.S. Code 2340, okay, which states that torture equals a deliberate act under the control and custody of law enforcement specifically intended to inflict severe pain or mental anguish. That's exactly what happened. I explained this to Lieutenant Harris, too, because I recognized his voice. I explained to him I was in the nurse's station, and all of a sudden everybody got quiet. And so if I was doing something so nefarious as they have to pepper spray me, why did they take me right back to my bunk in my bed in the isolation or whatever that was? Okay, so those are the facts. Okay, and then they said that I was passively being something, whatever, but that's still not grounds for force. The force applied whatsoever. Okay, so federal.
The U.S. codes that you're citing, so those would be enforced by a federal law enforcement agency. The state of Texas, to me here as a deputy for the state of Texas, I can't enforce the U.S. codes.
Okay, so sir, really fast. Okay, so I'm a member of a certain civil rights organization, and I have been for the last 30 years. My function with that civil rights organization, sir, is legal redress. And so I know for a fact a crime is a crime, federal or not. And being as a law enforcement officer, you must enforce that crime. That's Title 18 U.S. Code 242 states, whenever a law enforcement official under the color of law violates the system of civil rights, that is also a federal crime. Okay, so a law enforcement official is law enforcement always because you're acting under the color of law. Okay,
no, I'm not disagreeing with you. What I'm saying is I can't file a case in a federal court.
Then ask you to file in a federal court.
A federal agency has to file that in the court with the assistant U.S. attorney. I'm not saying that what you're quoting is wrong. What I'm telling you is I can't file that.
You can't enforce a crime though. It's the crime. So what you do is you take the crime and then you hand it over to the DAs and they decide which way it's going to go. That's how the application of the law goes. You take the criminal complaint, and then you pass it up, and then they decide whether it's going to go to federal or to civil, or to federal or to state. So that's a judicial decision, not an executive one. You guys are executive branch. The judicial branch decides what court is going to go to.
Right.
Okay?
And
so assault is assault. Aggravated assault.
That's not what I'm saying. We're talking about two different things at the moment.
Actually, sir, I'm sorry.
I'm talking about the U.S. code you're quoting, and you're talking about assault.
Right.
Assault is assault.
Aggravated.
It's
Sure.
different.
So, sir. Right, sir. But, sir, really fast. Federal law is state law. Okay? Federal law is state law. And the only time that the only time federal law ever comes in is they conflict with some kind of state law, which you're telling me about. This state can't do this, but federal law must be enforced at all times. That's been Hallett v. Rose. That's the case law to back up what I'm saying.
So, this occurred when? Do you have any idea when?
I think it was November the 6th, I believe. There's record of it because I was in that kiosk and I went to it 4 different times, and 4 different times they answered me. So there's a digital trace of that for sure. And then when I was talking to Sergeant Teague or whatever, he said, "Well, it looks like it was looked at and we didn't find anything." And then he was actually ineffective. Okay, which is also a federal crime. And so a federal crime is a state crime, sir. I promise you. Federal crime is a state crime. And so what happens is, like, they'll go to state court, and then the federal come after that for the civil rights violation. That's exactly how those police officers in Minnesota. They have the state charges, and then the federal come after them for the civil rights charges.
So was this incident already reviewed internally, or do you know?
I have no idea. I talked with Mrs. Hawks, and Mrs. Hawks kicked me over to CID, and CID did absolutely nothing for me. And even if it's an internal issue, so that's administrative. That's still in a criminal proceeding. That's administrative, okay? And so what happens there is you decide whether it's worthy or not to continue and put any kind of punishment on that. But legally, sir, that's not your determination to make. You're just going to take the complaint and kick it forward, okay? Because that internal is administrative, not criminal. Because if it was a criminal complaint would be taken, then the criminal complaint would say Charles Stark versus Lieutenant Harris. It would be a person to person. That's a crime.
I'm trying to look up the documents related to any of that.
Okay, thank you. Thank you so very much.
Yeah. Give me just a minute here.
No, take your time, Captain. I appreciate your patience.
Could this have been in October? Late October?
Possibly. I don't remember when I was. Yeah, it was late October. Yes, I think it was late October. Perhaps. And so, sir, really fast, since we're communicating effectively. But here's the situation, though, sir. The law says a pretrial detainee cannot be punished for any reason at all. Okay, and I can send you the case law with that as well. We cannot be punished.
What was the punishment?
He pepper sprayed me. That's the assault. That's the aggravated assault. He pepper sprayed me. Okay, when I wasn't a threat. So I know you guys have a threat matrix. And so he didn't go through that, number one. And then these guys tackled me and threw me down flights of stairs, and they handcuffed me when I wasn't a threat to them. Okay.
Well, it wouldn't be aggravated assault. It would be assault.
It wouldn't be aggravated assault because you had a weapon.
No, the pepper spray is not considered a weapon.
So it put me in pain, so that makes it a weapon.
That's right. Aggravated assault requires serious bodily injury.
Okay, so that's
the display of a deadly weapon, which is not pepper spray.
Okay, so pepper spray doesn't cause serious bodily injury?
No, sir.
Define serious bodily injury.
Permanent disfigurement or loss of use of an appendage or some form of that.
So if a person's incapacitated, they're no longer a threat. What's the point of tackling them and throwing them to the ground and handcuffing them? If they're not a threat for them, that's what the pepper spray is for.
We're talking about two different things again.
Well, sir, that's what makes it aggravated, though. Right?
No, it by definition is not an aggravated assault. We will continue to disagree on that one because.
Okay, we'll see. Okay, that's fine. And so, but you're agreeing it is assault, right?
Well, I don't know. I haven't found any documents to read to be able to determine what's taking place.
Yeah. Sure, there should be at least 4 from the
all I have right now is one side of a story. I can't make a determination based on one side of a story.
Okay. But you can take a criminal complaint from my side of the story.
Oh yeah, I mean we could certainly take a complaint.
Criminal. And so there was at least, whoever was in the nurse station that evening, there was, I think, from what the other inmates are telling me, there's like 6 officers that have tackled me for no reason, by the way. And so here's the thing, though. If my hands were by my side, I know for a fact, I was like 17 feet from him. I was not a threat to him. So just because I wasn't doing what he told me to do, that's not a reason to pepper spray me. I know that for a fact, okay? You don't pepper spray because I'm not the one that you go by. Because here's the situation. You guys put pretrial detainees in there with people who have already been convicted, and so they get treated equally, but that's not what the law says or the Constitution, okay? The pretrial detainees cannot be punished because we're innocent, okay? And so if somebody's innocent, you can't punish an innocent man. Okay, and you definitely can't put your hands on, and you definitely don't pepper spray him either. That's a misapplication of your authority. It's actually operating outside the scope of your authority, which makes him lose his quality. It makes qualified immunity, number one, but it also strips him of his power as a peace officer to even do anything past that. Okay, that's Edelman v. Jordan. And so once he pepper sprayed me, he stopped being a peace officer. So everything else that is fruit of the poisonous tree, and it's absolutely it's ridiculous. It's illegal.
So
that's what makes it torture. That's what makes it torture.
But by that logic, so every time an officer uses any kind of force, then he needs to be an officer, is what you're telling me?
Against a pretrial detainee, once he operates outside the scope of his authority, he ceases to be an officer.
But once again, I only have one side of the story. So let's say for the sake of this particular conversation, because I haven't found anything yet, I'm still looking.
Yes, sir.
That your actions, whatever those may or may not have been, warranted the use of the pepper spray.
It did. Verbal?
No, that's not what I'm saying. I'm saying, what if it did? If it did,
but it didn't.
It's no longer assault, right?
But hold on a second. It is assault because I'm a pretrial detainee. We can't be punished at all.
They're not punishing you. They're using a less lethal force.
Okay, hold on a second. That equals punishment, though.
To gain compliance.
The person burns that fit. Okay, but say
no, sir,
that's the issue, though. Okay, that's the issue.
If your argument is that the application of pepper spray inside a correctional facility is assault, then the answer to that question is no. Then there is no assault.
Tell me why. I want you to explain to me, sir. Seriously, I want you to explain to me how you have the authority to punish a pretrial detainee for any reason.
But it's not punishment, sir.
It's not? Okay,
no, sir.
So hold on a second. Okay, so if you are incapacitating me, that is punishment. If you made me go sit on my bunk, that's punishment. If you restrict my liberty in any way, that's the definition of punishment. Okay, any way. Even that command he gave me, he had the authority to do it, that's punishment. He's operating outside the scope of his authority. Because a pretrial detainee can't be punished for any reason. That's the federal law. It comes down and makes it state law, which makes it, and I saw your video your sheriff made, you follow the Constitution, okay? The Constitution says you have a right against the 8th Amendment, but since you're a pretrial detainee, you're actually covered by the 14th Amendment, not the 8th Amendment. 4th Amendment, you have due process of law and equal protection of the same law, okay? So you don't have the right to punish me if I'm not found guilty of a crime. That's how that works. So that does make it assault. The fact that you touch me in any way, any physical force, makes it assault.
Well, you and I will disagree on that one for sure.
I'm giving you the case law. You can look. I'm going to give them. You can look it up. I'm giving the case law. It says this at Back Smith, Supreme Court decision. Right. And so if the Supreme Court decides it, all courts must abide by it. That's also how it be.
So every jail in America that utilizes pepper spray, the taser, pepper ball gun, less lethal impact weapons, all of those are all violating the law.
If it's used on a pretrial detainee, absolutely. And that's the
then why hasn't it been banned in every jail in America?
Because you know what, none of people challenge it, but I have in federal court, I'll challenge it for sure. But that's you can't argue Supreme Court decisions. You can have your policies, but your policies are not law because the law says you can't do it. So let's think hypotheticals really quick. If a person's innocent, right? How do you punish an innocent person?
Well, I would disagree that that's punishment because they're not punishing you. They're gaining compliance from a non-compliant person.
Okay, so let me ask you a question. If a person's innocent, not guilty, why do they have to be compliant? What gives that person authority over me if I'm not guilty of any crime?
So what you're telling me is if you go to jail, you can act however you want,
so
even if it places other inmates or other staff in danger of injury.
Well, now that's something.
And that if they take any action against you, then that would be assault. That's what you're telling me.
According to the law, you're actually right.
That's reasonable.
Okay, so define reason though. Reason says this. Per this case law, it's exactly what happened from a jail. That's how the case law stemmed from, a jail incident where the person was a pretrial detainee, and they determined because he's a pretrial detainee and not an actual inmate, that's not an excessive force, it's assault, and it's illegal, it's considered torture. And I'll give you the case law, you can look it up. And it was this for very specific reasons like that, and that's why they made sure that the 8th Amendment claim wasn't viable. It was an 8th Amendment because there being the pretrial detainee status, but the 4th Amendment was pertinent. And that's why I have it filed in my civil case.
So this is a good contact number for you that I have.
Absolutely. Yes, sir.
I'm going to have to look and see where I can find it in the system, and I'll have to review it and get back with you. Okay?
To find what in the system? The
find any record of what you're telling me in the system.
Mm-hmm. Okay.
I have to access it's a completely different system, so I'll have to review that and I'll have to get back with you. Okay.
Okay, and so actually, as a matter of fact, this sergeant, the next day or day after, tried to come to me and have me sign some paper, and I did not do it. But they have record of it as well, because he told me of the whole slang, whatever, and I said I'm not signing that. And so he had it with him. So there is a written record of this.
Let me start with finding the records of your stay here and what took place, and then I'll get back with you. Okay.
Okay, perfect, sir. Thank you very much. Would you like that case file?
I'm sorry. What now?
Would you like the case file that
sure.
Back
that
what
to
I'm
me.
saying about free jump? Okay, hold on.
What you got?
Right here. All right, here it is. It's going to be here and then here. It is Hobart v. Taylor.
I'm sorry. What now?
I'm sorry. It's Kingsley v. Hendrickson. Kingsley v. Hendrickson, U.S. 135, Second Circuit, 2466 and 2475 in 2015.
Keeley, K-E-E-L-Y?
Yeah, no, Kingsley, K-I-N-G. Yeah, Kingsley v. Hendrickson, and that's in the United States District Court, 135, Second Circuit.
I'm just a black man with cameras.